Hi students, today's our topic is business law introduction. Business law, also called commercial law or mercantile mercantile law, the body of rules whether by convention, agreement or national or international legislation governing the dealings between persons in commercial matters. Business law falls into two distinct, distinctive areas. Number one is the regulation of commercial entities by the law of company, partnership, agency, and bankrupt, bankruptcy. And second, the regulation of commercial transactions by the laws of contract and related fields. In civil law, countries' company law consists of statute law in common law countries. It consists partly of the ordinary rules of common law and equity, and partly statute law to fundamental legal concepts underlie the whole of company law. The concept of legal personality and the theory of limited liability. Nearly all statutory rules are intended to protect either creditors or investors. There are various forms of legal business entities ranging, ranging from the sole trader who alone bears the risk and responsibility of running a business, taking the profits, but as such not forming any association in law and thus not regulated by special rules of law, to the registered company with limited liability and to multinational corporations in a partnership members associate forming collectively an association in which they all participate in management and sharing profits. Bearing the liability for the firm's debts and being sued jointly and severally in relation to the firm's contracts or tortious acts. All partners and agents for each other and as such are in a fiduciary relationship with one another. An agent is a person who is employed to bring his principal into contractual relations with third parties. Various forms of agency regulated by law exist universal, where an agent is appointed to handle all the affairs of his principal. General, where an agent has authority to represent his principal in all business of a certain kind, and special, where an agent is appointed for a particular purpose, and given only limited powers. Appointment may be express or implied and may be terminated by acts of the parties. The, the death, bankruptcy, or insanity of either the principal or agent, frustration or intervening illegality. See also agency theory functional. It is inevitable that in certain circumstances business entities might be unable to perform their financial obligations. With the development of the laws surrounding commercial enterprises, a body of rules developed relating the bankruptcy. When a person or company is insolvent, i.e., unable to pay debts as and when they fall due, either he or his creditors may petition the court to take over the administration of his estate and its distribution among creditors. Three principles emerge to ensure fair and equal distribution of available property among the creditors, to free the debtor from his debts, and to inquire into the reasons for the insolvency. Business law touches everyday lives through every contractual dealing undertaken. A contract, usually in the form of a commercial bargain, involving some form of exchange of goods or services for a price, is a legally binding agreement made by two or more persons, enforceable by the courts as such. They may be written or oral, and to be binding the following must exist: an offer and an unqualified acceptance thereof, intention to create legal relations, valuable consideration, and genuine consent, i.e., an absence of fraud. The terms must be legal, certain, and possible of performance. Thank you for watching the video.